Hi, everyone. Harry here to talk about the pretrial skirmish in advance of E. Jean Carroll's second defamation trial, which gets underway in New York federal court tomorrow, Tuesday, the 16th. Okay, we have an interesting sort of skirmish here where E. Jean Carroll has a very competent but also very aggressive lawyer, Roberta Kaplan, who has handled several very high-profile instances of either Me Too cases or flat-out sexual assaults that in high-profile instances, and she goes for the jugular. Here, they came forward and played Trump's or submitted to the judge who is trying this case, federal judge. Here's a very nerdy aside. You can turn this down for 15 seconds if you like. But when can you be in federal court? Why is it in federal court, even though it's a state law cause of action? Because the two parties are from completely different states. It's called diversity jurisdiction, and that's an instance where you want to have, or the framers want to have, federal courts available. Okay, back to our previously scheduled transmission. Robbie Kaplan sends a motion/letter to Judge Kaplan, no relation, saying you shouldn't let Donald Trump testify. Boom, period. And that's because you've already decided, the judge, in fact, already has decided that he is liable. He committed defamation. He sexually assaulted E. Jean Carroll, indeed raped her, in at least as rape is used in the common vernacular. That's a whole skirmish about the previous trial. Then lied about it and knew he lied about it. So it's all decided. Now it's just about damages. Roberta Kaplan comes in and says there's really nothing for him to say about that. We have expert testimony, but really he can't offer much. Moreover, there's a huge worry that he's going to turn this trial into a circus, and this one in front of a jury. So they cite last week's completely impromptu and improper diatribe in front of Judge Engoron. Remember the details there. He had to agree in advance to basically do proper argument. He didn't agree, so Engoron said no. And then at the last minute, he just grabbed the mic, and as Engoron was starting to admonish him about his limitations, he just started talking, and a lot of it was completely improper, meant for the press, etc. Engoron let it go on, to avoid an appellate issue, but completely out of line. The art and the doing it in the first place, and the argument was all out of line. So Robbie Kaplan now says, don't let him even testify here. Okay, and Trump's most Trumpy lawyer, I would say these days, Alina Habba, writes back a letter, but it makes a fairly strong point, or a couple of points. There are issues that are up for a decision at trial where his testimony could matter. Most importantly, punitive damages. So, I don't think this would be good for him, but definitely she's asked for, I think, 10 million compensatory, but punitive, and that could be the big ticket here, so that matters. And then when you come to punitive damages, you punish, and it can depend on just how sort of nasty and knowing the whole thing was. So his state of mind might be relevant. So Habba makes a good point that there is some relevant testimony that he could give. And Robbie Kaplan understands that, but she does a slightly aggressive motion. But I think what she would want to do is then retreat to the position of, okay, but really stitch him up the way Judge Engoron was unable to do in the fraud trial. Get these parameters, and Kaplan's a tough judge, and is I think kind of like Engoron. He's already he's not going to give Trump a lot of slack, and doesn't think Trump deserves slack. So stitch it all up in advance and be ready to come down with the hammer. If he testifies and starts saying improper things, boom, admonish him right then and there, and if necessary, initiate contempt proceedings. Remember the big difference here: it's in front of a jury, so you can't put the genie back in the bottle. If he answers a question, completely with irrelevant and improper evidence, you can try to give the jury a curative instruction, but they've then heard it. Now, will it really matter to a jury that's been sworn to apply the evidence that Trump says it's all, whatever he might say, this is all politicized from Joe Biden, completely improper? Would it matter, or does he just sort of do it for the press? That's sort of anybody's guess, but you can see the specific risk. So that's really what Kaplan wants to make happen. Now, all of this assumes that Trump would testify. My axiom number one is that people who listen to this YouTube know is he can't and won't testify in any criminal trial. Civil trials are different, in part because if you don't testify, there's an adverse inference. You can actually argue he didn't testify. You can assume, jury, that it would have been bad what he would have said. Still, he didn't testify last time around. Robbie Kaplan's a very good cross-examiner and just has so much to go on to show him to be a complete liar and clod and jerk. I don't see any upside for him. I don't see the overall upside for him in testifying, and my best guess is this is all a kind of theatrical skirmish. But anyway, we have and unless he says, I'm not going to testify, we're now going to go forward, I think, with Kaplan trying to impose very strict conditions. His lawyer saying, why are you treating me so unusually? And the very ready response being, Your Honor, can I just play for you the tape of what of his impromptu and crazed diatribe in just last week? That's all you'll need to know. Now, another aspect of here, he's tried a couple times to use the fact that Melania Trump's mom has just died to get delays. He did it last week in the fraud trial, and he's doing it again here. But although everybody noticed that after asking for this, he then went out to Iowa. But the actual funeral apparently is Wednesday and Thursday. So what Lewis Kaplan has said is, okay, look, you do not have to attend this trial, and you know it. You, of course, have a right to testify. So the trials, by the way, it's going to be pretty short. There's no liability involved. It's just damages. I don't even know what defense he puts on if he doesn't testify. So we're think about 4 or 5 days, a week or so or less. Now, so what happens? He wanted to put it all off because he's got to leave in the middle of the week. He at least, I think, will attend the actual funeral ceremonies for his mother-in-law. So he wanted to delay, always good in Trump land. And judge said, no, we planned this forever. We've got a jury, ready to impanel. Forget about that. But you have a right to testify. So if the case ends Thursday and you're I'm not going to forbid you from going to your mother-in-law's funeral, but you don't have to be present here. But if it comes to Thursday and the case is over, I'll just grant a continuance so you can come back on Monday, which would be a week from today, Monday the 22nd, and you can testify then. So you don't have to worry that your attending the services for Melania's mom will keep you from testifying, which is again, probably all a sort of theatrical gesture in the first place. Okay, so Kaplan, in two different ways, not giving him much slack, but we'll see exactly. I think now with these two letters, it'll be served up some kind of, if Trump testifies, here are the constraints he must exercise. There'll be a little bit of a fight over that. Maybe it'll just be kind of set to the side unless and until he actually testifies. All kinds of defendants say, I may well testify. If nothing else, it puts the other side to a ton of work. And then they say, oh, never mind. But Donald Trump, does that hugely. That's his MO. So I think the judge is well advised to say, I'll believe it when I see it. And at that point, we can work out the limitations. But I don't think he lets him take the stand. I first think it's a civil case, so it doesn't fall under axiom number one. Nevertheless, I think he probably won't take the stand. And if he does, I think Kaplan probably will put on some pretty severe constraints. So he's able. That's the issue with Trump. He wants to do impromptu stuff, and a judge wants to be in a position of saying, as soon as it starts, we've talked about this. Move on right now, Mr. Trump, and next, dismiss the jury and talk about contempt. Okay, so case starts tomorrow. I don't think he's got all that much to say. We'll see, but there are things that will matter for punitive damages and the like. I think we are going for another train wreck for him. And as with the civil fraud case, he is a judge, a pretty strong, headstrong judge, even, who is here's another little aside for 15 seconds. Way back when in the Department of Justice, I helped vet judges for slots, and I actually vetted and interviewed and spent a lot of time with this judge, Louis Kaplan. Anyway, he's going to be tough with Trump, not want him to hijack the case into a circus. He is, after all, still defaming E Jean Carroll after all this time. Remember, he did it on the courthouse steps before. So that's going to be, he'll try to rein him in. And then there'll be this whole separate little, back and forth if he, in fact, says, I want to testify. And my best guess is when push comes to shove, he says otherwise. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.